After a failed execution in February, Idaho's longest-serving death row inmate says a second attempt to execute him would be cruel and unusual punishment.
Therefore, violating his Eighth Amendment rights. Thomas Creech's attorney and the state presented their cases at a hearing last week. Our Jude Binkley listened in on their hearing and brings us more. Jude.
Well, Hunter, Creech's attorneys initially filed their petition just weeks after the failed execution. And since then, Creech's attorneys say their client has suffered psychological trauma related to those events. But the state says there are no grounds to vacate the death penalty.
When it appeared that those efforts were going to be unsuccessful, they did the right thing and opted to stop additional efforts so that we could evaluate next steps.
On August 29th, attorneys on both sides argued over whether a court should decide if a second execution attempt is off the table. State prosecutor Dayton Reed argued during the first attempt, the Idaho Department of Correction did not intend to cause intentional, unnecessary, or malicious pain, and the Eighth Amendment protects someone from malicious pain, but not a painless death, and that Creech was not biologically incapable of being executed. Creech's execution failed in February when KTVB reported IDOC tried to access his veins and failed after 8 attempts. Judge Jason Scott said he had a core concern the same procedures during a second execution could lead to the same outcome. The state also argued the firing squad, now legal in Idaho, could be used if lethal injection isn't an option. Creech's attorney, Garth McCarty, argued that isn't practical since IDOC hasn't built a facility to carry out a firing squad execution. He also said Creech suffered trauma during the execution when he laid on the execution table for almost an hour while doctors tried to establish the IV line. Creech's attorney also said pain was inflicted during the process and that Creech suffers trauma waiting to see if he will be executed again. Both sides cited a precedent from 1947, Francis versus Resweber, where in a split decision, the U.S. Supreme Court decided a second execution attempt did not violate the Eighth Amendment in the case of a 17-year-old from Louisiana named Willie Francis, who had the electric chair malfunction during his execution. Creech's attorneys argued the standards of decency have evolved in the 77 years since that decision came down. A similar situation recently played out in Alabama. The original execution of Kenneth Smith by lethal injection failed, and after an unsuccessful appeal to the Supreme Court, he was executed by nitrogen hypoxia earlier this year. No decision was made during the hearing. The judge says he will issue a decision in a timely manner. And Creech has had 12 death warrants issued since he was sentenced to death. Hunter, Morgan.
All right, Jude, so will this be heard in front of a jury or a judge?
So, Morgan, any post-conviction proceedings would be decided by a judge.
Okay. All right, Jude, thanks for the update.